So yes, our discussion would be on the topic of legal realism. It will be a short discussion given the paucity of time, but I have already shared a lot of readings, and you are most welcome to raise your queries and concerns regarding the same. So I'll restrict myself to the introductory, um, ideas. So realism, as you know, it concerns with reality. Okay, what actually happens within legal, in legal realism, it is essentially about what actually happens. Okay, so what do judges do? What do judges actually do? So this is a different approach to that of positivism. Okay, so as you know, positivists are essentially concerned with facts. Okay, certain kind of concepts. Okay, uh, realists do not concern themselves with concepts. Okay, they do not concern themselves with merely description of facts. Okay, they say that, well, there is a reality, okay, which is different from the way it is portrayed by the positivists. Okay, so that's how it is different, and they are far from the natural law approach that we discussed. So legal realists are highly empirical. They do not concern themselves with metaphysics. Okay, they do not concern themselves with conceptions, grand theories. They are concerned with the reality. So obviously they are highly empirical. So they have a peculiar position with respect to law. Okay, so what is the law? Is it what the legislators legislate? So unlike others, they would say that no. What is law then? Law is essentially the decisions of the judges. Okay, so they say that. So that's the extremity, that what is the law at the end of the day is how the judges decide and how it is actually applied. So they say that law, that is the decision of the judges, is the product of ascertainable factors. Okay, and what are those? So yeah, so judges personalities. Okay, so if judges hold their own ideological biases, they have personality traits. Okay, so those definitely affect the outcome of the judgment. So they say that, so yes, certain ascertainable factors are important. So what will be the outcome of a particular case will depend on all this. So that would include judges' personalities, the social environment, the economic conditions, business interests, trends, movements of thoughts, emotions, psychology, etc. So you cannot understand the law in the absence of also considering all these factors, which were considered as extraneous by many legal positivists. So, for example, Hans Kelsen wants to maintain purity of law. Okay, so they're saying that, well, you cannot escape this. This is the reality. When judges claim that they are merely adjudicating the law as it is, in fact, the outcome of their judgment is depends to a great extent to all these factors. And why should we not be bothered about that? So, as you know, with respect to 377 different sets of judges come to different conclusions. If law was so certain, then why would that be? Okay, so that's what they are talking about, that at the end of the day, law is what judges decide, and if that is the case, then you cannot escape and be ignorant of all these factors. So this is a very important position that they hold. So this is quite opposed to another approach, okay, another extreme that will come to that, also known as legal realism. Now, before we go into discussing in detail about what legal realism is all about, let me introduce to you that there are two different schools of legal realism. One that happened in America, known as the American realism. There is another known as Scandinavian realism. So some philosophers from Denmark, Norway. Okay, so these are the philosophers, who had come up with their own ways of looking at law. Okay, that's what we know as Scandinavian realism. So yeah, what is American realism? They say that law, as stated, okay, in the law books, in the rule books, is different from so law as stated, okay, by the judges is different from the law that you find in the books, okay. So for example, you probably heard many times, okay, what you are taught in the schools, okay, in the classes, in the from the barracks, from the constitution, and what actually happens in the corridors of the court, okay, are quite different, okay. So that's essentially what it is, okay. They say that, well, rules as you were taught, okay, are not exactly what happens in practice, okay. What happens in practice is quite different from the rules, okay. So that's why some of them are known as rule skeptics. So they would say that, then where does law, where do we find law then? Do we find it in the rule books? No, they see that real law lies in the interpretation and finding facts. Okay, so when judges adjudicate, they find facts and they also interpret the law. The real law lies there. So that's essentially all about American realism. So one that is skeptic about rules, the others that also say that, well, facts also matter. You cannot be ignorant of that. So you also have fact skeptic, especially Jerome Frank. Then as opposed to that, you have Scandinavian realists, okay? They are concerned with, a scientific way of looking at law. So they want to come up with scientific theory of law that does not involve metaphysical explanation. So psychology could also play a part there, okay? But those metaphysical ideas, okay, concepts that we discussed in jurisprudence, earlier, and they are critical of that. So they do not like this idea of conceptual jurisprudence, okay? So yes, these are the two broad categories. Okay, so you have many different, important, Scandinavian jurists like Axel Hagestrom, then Alf Ross. There are many that you might study. Now, as I told you, legal realism is opposed to another extreme approach known as legal formalism, and one formalist that you have studied is Ronald Dworkin. There are other formalists as well. So what's the broad idea that they have? Their broad idea is that law is a closed and gapless system of rules, that in a legal order, okay, there is no gap in the law. It's a complete whole system. So if a new situation comes, okay, that does not mean that rules do not exist to address that. All you as a judge have to do is use deductive logic and then apply those general principles to specific cases, okay, so that you come to a specific outcome. So their essential idea is that when judges adjudicate, they do not create the law. They cannot create the law for many different reasons that we have already discussed, okay. So when judges adjudicate, they merely apply the law. Because if they create the law, then you'd say that there is a gap in the law, okay? That's not acceptable to them, okay? They merely apply the law. If you remember, that's the position which is also held by Ronald Dworkin, as you have studied. So they say that policy plays a part in the making of the law. So that is the concern of the legislators, not of the judges. So you might notice that there is a difference between positivism as we understand and legal formalism. It's a kind of extreme here. So as you know, some positivists, not Bentham, other positivists like Austin and Hart, they say that yes, judges do create the law but then it is law because they have been delegated the lawmaking power, okay. So that's the position that is held by them, okay. But as opposed to that, formalists say that judges cannot make the law. They ought not to make the law. They cannot make the law. They merely apply the law. So that's the difference. Now, how true is this, assertion made by legal formalists? Well, as you know, language is quite complex and uncertain, okay. The same words convey different conflicting meanings, as you will see when we study interpretation of statutes. So there are many different theories within linguistic studies that I think it's not the right time to introduce those to you, but in radical jurisprudence, we'll talk about those ideas later on. But for now, it's sufficient for you to know that uh, language is quite uncertain. It can, same word could convey different meanings. Okay, there is complexity in it as well. So when legislators legislate, they try their best so that law is able to address future situations that might arise. But because of the way and the pace with which things change, okay, it's just not possible for legislator, even the best legislators, to foresee the questions now and in the future. Okay, and there is also the question of factual uncertainty. No legislator could foresee the future problems, okay, that might arise. So yes, positivists say that in those situations, if there is a gap in the law, judges do in fact create the law. But formalists would say that, well, that's not the case. If the general principles are laid down, those general principles are sufficient to address every future, different fact situation that might arise. So yeah, that's essentially what formalism is all about. Okay. And what positivism would say as opposed to formalists. Now let's proceed to American, realism. Okay, so they say that law as it is, okay, as positivists say, okay, must not be confused with, what law as it ought to be. So like the positivists, they're also maintaining the same, idea that law as it is should be kept separate from law as it ought to be. Okay. But then how do we find what the law is? Okay, how to find the law as it is? Can we find it in the rule book? Well, that's what positivists say. Well, where is the law? The rules tell us the law. Okay, you find it in the rule book. But then realists are not of the same opinion. They are rule skeptics. They say that, well, rules are merely rules. What then is the law? Law is how it is actually applied and adjudicated by the judges in specific cases. And there are so many factors that affect judges, okay, and decisions. So yes, so they say that rules do not really represent the law. Then how do courts actually reach decisions? They say that they make moral decisions clothed in the language of logic. Okay, so quite often when judges say that we are deciding the matter based on this rule, okay, these principles, so they do the same. Okay, they make those decisions. Okay, but they say that we are doing it based on this logical deduction. So this is what the rule says. These are what the precedences have been so far. Okay, and in the light of these facts, this is the conclusion that we arrive at. So if you read a judgment, you will see that there are hundreds of citations, okay, of other judgments, of other rules, okay, and then they conclude something. So they say that yes, we are deciding based on some existing rules, but that's not the case. Some ideological or moral biases definitely do play a part in how they decide. So they say that, some of them say that they have already decided. They only, post hoc, they, once they have decided, they basically rationalize, okay, saying that, well, this is how, this is what the law says, but in fact, this is what they want, and once they have already arrived at the decision, they after that rationalize it. So realists say that, well, just drop that pretense and reform the law. Just accept it that you guys make laws. So drop that pretense, okay, and be very frank about it. So how we are to know what the law is? Okay, it seems that only when the judges adjudicate do we know what the law is. So is it possible for us to know beforehand as to what the law is? They would say that, well, that's not the case. We can't do that. So remember that prediction based on probabilities that we had studied in Bentham's positivism. Okay, so that's what applies here. So we will never know for sure what the law is. We can only predict what the law is, based on, for example, you observe judges' traits, the judges' ideological biases, philosophies, whatever it is, okay, and based on that, you have to predict what the outcome of the case would be, and that's how, based on that prediction, you will know what the law is, okay. So yes, within this, American realism, there are two problems. Okay, two different approaches. Okay, one group which we know as fact skepticism. Okay, so Jerome Frank being one, and then you have rule skepticism. Okay, so you have Holmes, for example, one such. Okay, so fact skepticists essentially say that, well, yes, we know that, yeah, rule skepticism is a real problem, okay, but then what about also facts? So for example, some murder happens here, there has been some witnesses to that event, but when they actually go and depose, okay, before the judges, okay, in the court, you never know what they are describing is actually what has happened. And scientifically it has been shown that people sometimes imagine things happening in their mind. And in fact, in courts, in many important cases, it has been historically the case that people are not able to recollect exactly what they have seen, or they interpret it in their the way they think that it has happened, whereas reality is quite different. And what if the incident had happened in the evening or in the night? How do you know who has done it? So, or there could be, for example, the judge has not eaten properly while deciding the matter. So there are scientific studies that show that with respect to bail applications, judges tend to be more generous in giving bail immediately after they had food. But as the day passes, as if they are hungry, because of their mood differences, they're less likely to accept bail applications. So yeah, so what about those? Okay, these are not really problems with rules, okay, but in fact about facts. So yeah, that's what fact skepticism generally is. Okay, then you have rule skepticism that we already discussed. They say that rules do not really tell us what the law is, it's what the judges actually decide. So that's why you have these two different approaches to realism within American legal realism. Now, one of the most important realists that we have is Oliver Wendell Holmes. Okay, his approach is very important. Okay, so his work has four broad themes. Okay, the first is that law is an evolutionary process, that law is not static, it's constantly evolving. Who's evolving the law? Obviously, law evolves when it is legislated, okay, based on societal changes. Laws are enacted, but then judges contribute a great deal to that as well. Okay, so while between these changes in the law made by the legislature, as the changes happen in the society, incremental changes happen in the society, law also has to catch up with those changes. Okay, so it says that law is an evolutionary process. It is a product of experience and not logic. So you cannot from general principles, by virtue of logic alone, come to specific conclusions. There are experiences, okay, that matter. Okay, so it's saying that law is a product of experience and not logic. It reflects society's adaptation to a changing world. So yes, law has a evolutionary nature. Says the law embodies the story of a nation's development, and to know what it is, we must know what it has been and what it tends to be. So yeah, so there's a very important remark that he's making, that law is an evolutionary process, quite opposed to what formalists would say. Okay, now why do they say so? They these philosophers like Oliver Wendell Holmes say so for some very specific reasons. So one being that, okay, society changes, but law does not change as fast as the society changes. So there's a lag between the changes, between societal changes and law's response to the societal changes. Okay, so there is a inertia in the rules of law. So the society might change to such an extent that the reason for certain laws existence might not even there. Okay, so in such situation someone has to step up and do the needful. So judges quite often do that. Apart from that, he's also talking about legal evolution. He's saying that courts play a very important role in the evolution of the law, okay, by actively reforming the law to suit the changing conditions. So we notice that there is a lag, okay, between changes that happen in the society and law's response to it. Once that is there, okay, the court play a very important role, okay, very important role in the evolution of the law, so as to, okay, so they actively reform it so that the law is suitable to the changing conditions. So as you know, so for example, a law has been enacted to address matters related to telegraph, but then so many things have changed. Okay, now we have so many other ways of communicating. If a law is not made to address those changed circumstances, the judges will have to apply the existing law with necessary changes, okay, as are required, so that that law can be applied in the changing circumstances. So yes, that's very important. Judges play a very important part, okay, in the same process. Okay, so he's saying that, he says that it is especially the case when it comes to appellate courts. In courts of first instance, okay, not much philosophization happen, not much philosophization with respect to laws happen. So especially in the decisions of the appellate courts, okay, they say that they are presented as a logical deduction from established rules, but in fact they are legislative in nature. So they are the ones who change and adopt the law so as to address the changing, okay, societal changes in the society. So one more thing that you need to remember is that rule skeptics are essentially about these appellate courts, whereas fact skeptics are essentially about the lower courts, or the courts of first instance that deal with facts. So they say that, okay, so there's essentially philosophers like Holmes say that appellate judges perform a legislative function in attuning the law to what is expedient for the community concerned. So they say that judges actually make the law. Okay, sometimes they are aware of it, sometimes they do it unconsciously. Okay, so they even if they know, they do not admit it. Okay, there is a problem with judicial legislation and certainty. If you remember, we studied Lon Fuller, and for people like Fuller as well as for other positivists, certainty in law is very important. It's very important for them. So if judges actually legislate, then we sacrifice something with respect to certainty. So it says that statutes, okay, depend for their efficacy on the courts, and hence they are not law until enforced by the courts. So yeah, statutes are there, but at the end of the day, how best it is to be applied. Okay, so that at the end of the day is done by the courts. Okay, so that's why philosophers like Oliver Wendell Holmes would say that what you find in the rule books are in themselves not the law. How the laws are actually applied by the courts is the law. Okay, so we have this Badman's point of view that we had discussed earlier. So how do we know what the law is if the judges are the ones who are legislating? Okay, so in order to know what the law is, you have to look at it from Badman's perspective. Okay, suppose you want to commit a crime, so you will look at how likely is it that if I do in fact commit the crime, then I'll be able to get away with it. Okay, I'll not be caught. So if I'm caught, how likely is it that it will end up in trial? And if it ends up in trial, how likely is it that I'll actually be convicted? based on all those calculations, you ultimately decide as a bad man, whether you are to go ahead with committing that crime or not. Okay, and if the conclusion is that, well, you can commit it without getting caught or being or punished, then you choose to do it because you stand to gain more. Okay, so if you are able to successfully escape the law, then we would say, okay, from the badman's perspective, that there is no such law and there is no obligation. Okay, so that's the badman's point of view. So they would say that law, for these reasons, okay, turns out to be nothing more than predictions of about how courts will decide a dispute. So if you were a bad man, this is what you will say. How likely is it that I'm going to be in a court? How likely is it that I'm going to be tried? And how likely is it that I'll be the matter will go against me in the court and I'll be imprisoned or fined, whatever. So yes, what the law is basically prediction by the bad men. So this is essentially what Holmes' idea of legal realism is. Now this is a very interesting approach. Okay, so legal realists had raised this problem with respect to. Their criticism was essentially as opposed to the legal formalist of their times, and also positivists like Bentham and Austin. Okay, so someone had to save positivism, from this, onslaught, and so we have already studied in the works of H.L. Hart. Okay, certain answers to these criticisms which have been developed by legal realists. Okay, so if you remember in the example of Core versus Penumbra, which is given by H.L. Hart, he's saying that, well, no, we should not be so skeptic about rules. Okay, there are many questions on which there is not much disagreement. We all agree on all that. Okay, it is only in those penumbra of uncertainty of meaning that judges actually legislate. So that's the answer which was given by H.L. Hart. But as opposed to H.L. Hart, there is another formalist that we discussed. That is Ronald Dworkin, who says that legal system is not merely about rules. So if you think of legal system only in terms of rules, then you will see there will be gaps in law. But there is something important that we are missing. Okay, and those are principles. That in those cases where rules are not sufficient, judges definitely refer to principles to decide the matter. So, for example, the Riggs versus Palmer case, which was discussed by Sachin sir. So that's another answer to, again, H.L. Hart's response to realism by Dworkin, who is a kind of legal formalist. So yeah, so that's what realism is essentially all about. So I hope I just kept it as simple as possible, and I hope you guys are able to understand this. And if there are any difficulties in understanding legal realism, feel free to ask me questions, and also refer to the materials that I had suggested earlier, and that should be enough from examinations point of view. So yeah, all the best to you, and best of luck for your examination. But yeah, I should also tell you that apart from that, within America, okay, so American realism, we have fact skeptics like Jerome Frank. Those readings are also available. I have already shared, and there are also others like Carl Lewin and all. So kindly go through all that, and it does not make sense to talk about realism really without also referring to cases. So you can refer to hundreds of cases, okay, to either support or go against these remarks which are made by legal realists. But for now, we'll stop here. So thank you. All the best for your examinations.